Welcome to Employee Benefit Plans and Business Sense.
Hey everyone, welcome back to an all-new episode of Employee Benefit Plans and Business Sense with Doll Lank and Kathleen Bass over at KLB Benefits Law Group. I am your host, Mike Leon. You know, Doll and Kathleen, they've been helping employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. They've got decades of combined experience in employee benefits law, and they've been guiding clients through compliance matters, corrections, the IRS, and Department of Labor audits. Today's episode, we're going to be talking about that acronym that lives in their world that I'm sure they hear all the time, and you've heard it here on these episodes, ERISA. What is it? What does it do? Why does it matter? I sound like Arnold Schwarzenegger in Kindergarten Cop. And for all the employers offering those benefit plans, why does it matter? So, ladies, it's good to see you guys as always. Kathleen, let me start with you here. Okay, what the heck is ERISA? What does it stand for?
Thank you very much, Mike. It's good to be here. So, ERISA is something, that anyone who deals with an employee benefit plan, whether it's an employer or an employee who's receiving benefits, they've heard ERISA. And ERISA sounds like it could be somebody's name, but it's just an acronym for the Employee Retirement Income Security Act. And basically, that's one of the two major bodies of law that govern employee benefit plans.
Yeah. And what is the general purpose of ERISA? What's it supposed to encapsulate?
That's a good question because it can be kind of confusing because there are so many laws that impact employee benefit plans. And ERISA is, their main purpose is to make sure, because it's governed by the Department of Labor, so they're interested in fairness to the labor force, to the employees receiving the benefits. So its main purpose is to add in both protections for employees, including making sure that they get all the information they need to make sure that they are receiving their benefits and they understand their benefits, as well as their rights. And it also puts a responsibility onto the employer and all of the people who are, touching the plan to have some fiduciary responsibility for those benefits.
Yeah. So in that vein, Kathleen, what does ERISA require from the employers who sponsor these benefit plans?
Well, it's interesting because there is an overlap with the Internal Revenue Code. And ERISA has like 4 different sections called titles. And the first title is the one that requires an employer to provide information to the employee, such as information about their investments, like in a retirement plan where there is a slate of investments, to inform employees about any default investment that the plan may have. If there's a safe harbor plan or an automatic enrollment plan, there's notice requirements that have to go out before the beginning of the plan year. Every plan has to have a written plan document and a summary plan description that summarizes the pertinent provisions of the plan for employees. Then there's also, it requires the employer to act as a fiduciary, take on the responsibility for the care of the plan. And ERISA also has certain baseline requirements that the plans must meet. Like, for example, in a retirement plan, you can't keep an employee out who's due to age past age 21. You have to, you can't require service for eligibility more than, a year. There's rules about not being able to, ERISA provides that a plan, there's no assignment of the benefits of the plan to a third party. So if someone goes into bankruptcy, they can't take any of the money out of the retirement plan. There are some exceptions to this anti-assignment, like in the case of a divorce, but there's also requirements that the plan be operated for the exclusive benefit of its participants. There's certain benefits that have to be protected. And another important one that Doll and I deal with a lot is sort of the prohibition against certain transactions called prohibited transactions. So, it's a lot of the fiduciary requirements, have their fingers all over the plans. There's governmental filings, the annual Form 5500 that has to be filed, which is the way for the government to kind of keep tabs on the plan. And ERISA requires that all benefit plans be covered by a fidelity bond to make sure that any losses to the plan are recovered, or So that's kind of like it's a lot.
Right. So in that vein, Kathleen, can you kind of, I guess, give us some real world examples here of like how ERISA requirements would show up in real world plan administration?
Yeah, I mean, one of the big provisions of ERISA requires that a plan have a written claims procedure so that employees will know if they think they didn't get a benefit they were entitled to, or that they are entitled to a benefit, that they can make a claim for it, and that there are procedures that both the employee has to follow to make that claim, but also the employer has to follow to make that claim. And also then there are appeal procedures. So if in the first round of the claim, there's a negative decision against the employee is informed that they have a right to appeal, and these are the steps that they need to take. And also very important in both claims and appeals is a time frame by which they have to make their claim, and then their right to a lawsuit. If they go through all of the claims procedures and they still think that they aren't being heard, or they're not getting what they want, and they think they have a valid reason for it, they can take it to court once they've gone through the plan's claim procedure. Yeah. And so that's one that really it affects the day-to-day administration of the plan. Both from a procedure standpoint, and also there's a lot of disclosure requirements, letting the employee know, what the next steps are or what their rights are.
I just wanted to add that the ERISA covers retirement plans and health and welfare benefits, many different health and welfare benefits that an employer might offer. So it's not just retirement benefits that are subject to these claims procedures. It's also denial of coverage under the plan, under an ERISA plan for medical benefits, for example.
Oh, okay. And that's good to know, because that piggybacks into the follow-up. So Kathleen, can you expand a little bit more? Are there other type of employee benefit plans that are subject to ERISA that maybe we haven't covered so far?
Yeah, I mean, so it's a little bit of a misnomer for the R in ERISA stands for retirement. So that makes it sound like we're just talking about retirement plans. And that's not true. As Doll said, that ERISA covers basically any plan that an employer sponsors for benefits to its employees. So it also, that would include the health and welfare plans, disability insurance plans. It includes life insurance plans, pretty much almost any plan that an employer would sponsor for its employees, although there are exceptions. For example, plans established by a governmental entity are accepted from ERISA. Church plans are frequently accepted from ERISA. So, that is, it's pretty much anything. There are exceptions, like things that are just payroll practices, but the assumption, if it's a plan sponsored by an employer for its employees, it's more than likely covered by ERISA.
Yeah. Well, adding on that, I mean, what happens if, like, that's one of those plans that you mentioned, the church one, just as an example, or you can use a different one. What happens if a plan is like not in compliance with ERISA and the employer is using it? Like, what kind of consequences can the employer face if the ERISA obligations are met?
It really depends on what the failure is, what the problem is. I mean, if they don't have a fidelity bond, then the fix is usually to just go get a fidelity bond. There isn't like a specified penalty for it. But if there is a prohibited transaction involved, I mean, that can be, the consequences of a prohibited transaction are very expensive. Not only do you have a certain amount of excise tax, but it grows exponentially. And Doll's kind of our prohibited transaction expert. So you can probably explain the consequences one much in more detail than I can. But I mean, those are things that they just sort of every year you now have a new failure. And so, you end up paying interest on 2 failures, and the next year it's 4. So, and then the actual correction of whatever the prohibited transaction is could also be very expensive.
Yeah, and to add on that, a lot of ERISA violations, whether they're prohibited transactions or others, are there are schedules on public websites of the daily penalties for a failure. Failure to provide this, failure to provide a copy of the plan document when requested, failure to file the 5500 timely, et cetera. And they're usually recited as a daily number that just can go up and up and up. And then in the case of the prohibited transactions, they multiply like bunnies every year. That it remains uncorrected and unreported. So the incentives under all of ERISA are the penalties are written to incentivize prompt action to correct and report and pay a tax that might be due. It's not that the government wants to collect a lot of penalties. It's they want to incentivize employers to do the things that ERISA requires. Don't do that prohibited transaction. Do provide that notice to your plan participants. Do file your 5500 on time.
Yeah.
And the 5500 issue, I mean, the penalties for filing those missing or late can be really big. If you look at those numbers, it's, could be in the millions of dollars, but they do have a program where you can file them late and pay lesser penalties. Also, if there's a DOL audit that comes in and they find, issues, they can issue a sanction on top of whatever else has to be done to correct it. Then they can, and those sanctions are not, there's not like there's not like a specific set menu of what the penalties might be. It's kind of up to the reviewer. So those can also be very expensive. So the bottom line is fix it. Fix it before you get caught.
Penalties are meant to remind you, right, to do it right the first time. So,
exactly.
Ladies, as we kind of wrap here, and Doll, you can kind of piggyback on Kathleen, but can a plan sponsor transfer ERISA responsibilities to another person or another entity? And when those responsibilities are transferred or delegated, if they can be, what still remains with the plan sponsor?
That's a great question, Mike. So, I mean, the answer is that there are, and when I'm talking about plan sponsor in response to your question, I also mean the plan administrator, which are 2 different titles. It's usually the same entity, which is the employer, but they can contract with third parties to take on a lot of these responsibilities, things like a third-party administrator who does sort of the day-to-day administration of the plan. They can even hire someone who takes on much of the fiduciary responsibilities. They can hire a registered investment advisor. So they can delegate a lot of these to these third parties. But and then what happens is if there's some problem, those entities might be responsible by contract to the employer, but the employer ultimately, no matter how much they delegate, they're ultimately responsible for, choosing those third parties that they're going to, delegate and give responsibility to. And, they're also still responsible for things like, they may have an RIA who comes up with a lineup of investments, but they are responsibility for monitoring all of these things. So they can't just like hire someone and just like let it be. They need to be keeping an eye on how that person is performing, periodically make sure that they're not paying too much for those services, and generally, keeping their finger on the pulse of what's going on in their plan, because they retain the ultimate responsibility.
Right. I like to say there's no such thing as set it and forget it in ERISA. And also there's no such thing as a turnkey solution, which you see in marketing materials sometimes. It seems too easy. Well, it is too easy. You can't delegate everything.
Right.
So,
yeah. Well, it's a great way to end it. And ladies, thanks for the time, the insights, breaking this all down as usual. Appreciate it, ladies.
thank
Our
you.
pleasure.
And thank you to everyone out there for listening to this installment of Employee Benefit Plans and Business Sense. If you've got any additional questions about ERISA, how it applies to your retirement or health plan, need some clarity around responsibilities, do me a favor, visit klblawgroup.com to connect with Don and Kathleen today. And one more favor before you go, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.